Hi, welcome to MediatorPodcast.com, a podcast and video series about mediation, negotiation, and collaboration. My name is Melissa Gragg, and I'm a valuation expert and divorce mediator in St. Louis, Missouri. Today, we'll be discussing divorce mediation versus litigation. You don't know what you don't know. Basically, the differences between divorce mediation and litigation with Rosalia Labate. She's located in New York, and she's a certified divorce financial analyst and certified public accountant. She's known to provide service in financial forensics and divorce finances and business valuations. Welcome, Rosalia. How are you?
I'm good. Thank you so much for having me, Melissa. I really appreciate it.
Well, this is awesome. I think that, for the most part, when people go through a divorce, they're getting divorced for the first time, although there are a tremendous amount of second divorces and gray divorces. But in general, people talk about how bad divorce litigation is and how divorce mediation is this holy grail option. But realistically, what we're going to talk about today is just the differences. Assuming that you have any possibility of going through your divorce in a way that is best for you, it's really just a way to understand financially how these two things are different. And then obviously legally, if you needed more questions answered, you would reach out to an attorney. But if we get started and we're both valuators, we're both, looking at financials and divorce financials in a similar fashion, but we're going to give two different perspectives, not only from operating in different states. I'm in Missouri, you're in New York, but also, and that's important because things are state specific, but also we will see different things. And so they're both of our experiences, but also maybe some stories woven in there and kind of big general terms. We plan on talking about this topic going into the future because we think there's a lot of differences that we can enunciate and get you a little bit more prepared. So, Rosalia, as we start this off, maybe you can tell us one of the big differences that you see kind of initially, even in the process of divorce mediation versus litigation.
So I can be brought in as the mediator or the financial neutral. So I can mediate the whole matter or be brought in by a mediator to work strictly on the financial part in things. And so from the divorce mediation perspective, I have Fred Neffel coming in, and I can work with both of them together, and they can kick and scream, and we can work that out. We can hash that out. And if I can't hash it out with them, we could bring the mediator in and hash it out with the mediator. Whereas in litigation, Fred goes to his attorney, Ethel goes to her attorney, and that's how everyone communicates. And generally, I'm on one side or the other. So there's quite a time lag involved as well between mediation and the litigation process. But to me, in a nutshell, that's one of the biggest differences between the two processes.
Well, and I think if we even go back just a little bit further, there's there's going through this process, you can just talk with your spouse, right? And that's like a normal, like you don't need anybody else. Mediation, and there's also collaborative divorce, are kind of in the middle of doing it yourself and going to litigation. And in the middle space, there's something called a financial neutral, or a way that we operate from a financial standpoint that is almost in addition to a mediator. And so I don't know if you can talk a little, because I think that this is a little bit of a misnomer, right? That all mediation is the same, all mediators are the same. And when we're talking about a phrase that I kind of have coined, financial mediator, there's this middle ground, and maybe we can talk a little bit about how you deal with that middle ground. But that's where this concept of a financial neutral, which really is coined, that phrase is coined in collaborative law, right? So, but it also is a very good term to kind of understand how can a financial person either be your expert or be your neutral or an unbiased kind of third party. So talk to us a little bit about how the financial person also could be involved, but there could be a main mediator, because I don't know if people totally understand that.
Okay, so I've worked mostly again in situations where the mediator, who can be an attorney or have a background in social work or therapy or and really anything, anyone in anyone could be a mediator with the training that's involved. And a lot of times I'm brought in because there is a lack of understanding in terms of the finances. So let's use Fred and Ethel again. Fred and Ethel want to mediate, and Ethel has no idea how much money she spent. She never took care of the finances. And so I'm brought in to work together with both Fred and Ethel, and both parties will be transparent so that we could get to the finish line with that. And say Fred, is an executive and he's working on Wall Street and he has deferred compensation. Again, Ethel doesn't know what it is. She doesn't even know she's entitled to it. But Fred puts it on the table and we determine what's marital and what's not. Whereas a financial neutral, and Melissa, we spoke a little bit about it, right before getting on the podcast. But here in New York, a court can appoint you as a financial neutral in litigation. So the neutral will prepare, let's say, the business valuation or do an income stream analysis to see how much money the moneyed spouse is earning. And it's presented to both parties. And either party can still go out and get their own expert and then duke it out at trial. So in effect, you're going to have 3 experts fighting it out over the same pot of gold, if you will.
Well, and I think that the importance of including somebody from a financial aspect in mediation or litigation really is to help the parties, to help the clients, to help the couple and understanding what their options are. So mediation is usually where you're discussing options with the mediator, and the mediator is kind of facilitating these discussions. And then you can also add attorneys. So you could also have your attorney there. In some cases, I'm in the middle and maybe not necessarily operating as a mediator, but really giving both parties the financial reality of the situation. It's almost like empowering them with knowledge so that they can make the right decision for them, but we're not coming in saying, you should do this or that until we talk about a business valuation. But until then, talk about a little bit of that.
One thing that I really, really want to bring across, I had gotten a phone call from someone who literally was on the eve of her signing off on a settlement agreement during mediation. And there was the mediator and there was the financial neutral that had prepared all of the financial information. I took one look at it and I was mortified for this client. And I asked her if there was a consulting attorney on board. She didn't know what a consulting attorney was. And she didn't understand what the financial neutral had prepared, nor had the financial neutral listened and answered her questions. So may or may not be financial in nature, but it is very important in mediation to make sure that you are heard. It is, I think, very important in mediation that you understand all of the financial work that I've done, that Melissa has done, you're allowed to ask those questions and you're allowed to have the comfort level to move forward.
Well, and it's an interesting thing because you talk about a consulting attorney, and I kind of put in trial attorney, but that's not really the comparison. But it enunciates an issue in divorce that when we say, you know what, I think I'm going to get divorced, the first thing is like, how do I file? Like how do I do this in order to file something? Because I want to get it started, right? And the first thought is to hire an attorney, which I'm not saying is right or wrong, but what happens in litigation is sometimes that attorney starts to push everything forward, including the financials. And a consulting attorney is different. Can you kind of enunciate how they would, like how you can even look at a consulting attorney and what benefit they provide, or what do they do? Because as you describe it, I think people will understand it a little bit more.
So generally, I've seen a consulting attorney hired towards the end of the mediation. The mediator will draft the settlement agreement, and the party will go to their consulting attorney and review the settlement agreement with their party. So Ethel goes to her consulting attorney, Tom, and they both review it together to make sure that it's fair to Ethel, to make sure that there's nothing that's missing, to make sure that it's a good agreement for her and it's fair to her. And so the consulting attorney is really kind of your backstop, so you feel comfortable that you're not signing your life away in a legal and a financial matter without understanding everything. I've also seen consulting attorneys work during the process with the mediators when it's highly contentious, but there's still an opportunity to work through the mediation.
Well, and it might be even helpful to compare it to a consulting expert versus a litigation expert, right? It might be easier to kind of give an example of how we operate in those two different facets, and it'll be very similar for an attorney as well. But it's basically a consulting attorney is also pulling in somebody to take a look at the information. If you don't have, like you have to have an advocate, in my mind, from a legal perspective, somebody that's like your cheerleader and telling you what the law is, and maybe a cheerleader from the financial perspective, and to treat those as different than a mediator or a financial neutral, because those two are going to be working together with everybody. Whereas the others, in normal litigation, you will hire experts and they go and fight about everything, specifically business valuations. But talk a little bit about how we could be hired differently if it's a consulting situation versus litigation. And do you do those, right?
Yeah. So in that situation where the woman called me on the eve of signing her agreement, in that case, I was clearly the consulting expert. And I, over a period of time, she agreed to bring on a consulting attorney. And both of us were able to successfully explain to her what was wrong, not only with the agreement, but with the business valuation, and what was wrong with the other financial work vis-a-vis the settlement proposals that the financial expert had come up with. It clearly was favoring the other party. It was favoring the husband more so than it was her. She couldn't see it, but she had a gut feeling. So I'm there just for her in that scenario. In terms of a litigation expert, I'm generally hired by the attorney, and I work theoretically for the attorney. And I'm still working for the client, but because I'm a CPA, I'm supposed to be independent and objective, which is what we strive to be. And I can go in and testify on behalf of my client in terms of what I see. So I'm really representing one side.
Well, and a couple other things about kind of that situation is that, you know, when you're getting divorced, there are financial matters and there are legal matters. And the reason why we kind of hire an attorney and sometimes talk to them about financial matters is because they're putting together financials, they're putting together some information, or they're talking about alimony and child support, which are kind of on the fence of, is it a financial matter or is it a legal matter? It has both. So talk to us a little bit about when you get included in a litigation matter or a mediation, you know, is there a difference in the financial analysis or the collection of documents? And, you know, how do you kind of proceed? And in general, I will say, you know, in general, litigation is much more formal and mediation is based on that mediator or a group of people that kind of mediate together in a certain area. But there are differences or there are unique things maybe that you can do in a mediation that you may not be able to do in a litigation. And part of it is getting closer to settlement, you know?
Right. So in mediation, I'll come up with a document request list, and it'll go to both parties. And they really, I've been lucky enough to see them work together to get me the information that I needed. You know, whereas in litigation, I've got to come up with the document request. It's got to go through the attorney and it's got to go into legalese language. Then that goes to opposing counsel. Opposing counsel sits on it and it comes back. And more often than not, there's chunks and key bits of information that we need that we don't get. I'm sure you see that all the time, Melissa. You're shaking your head, yes. You know, it's so much more time consuming. It's so much more expensive. And it does not lend itself to cooperation as it does in mediation. In terms of the financial analysis that I do, more often than not, in litigation, and I don't know if it's a function of because I'm in New York or if it's because of the attorneys that I work with, but a lot of times the attorneys want to do the settlements with the clients, which I don't understand because I've actually had clients call me to have me look at these settlement proposals because they, you know, again, it's intuition that they didn't agree with it. And they were right. They were absolutely right because the attorney's the legal person. We're the financial people. And there's a great big difference between the two. You know, in mediation, we're looking at the proposal together. It's the three of us or the four of us if the mediator's involved. There's an extra layer there of working together to compromise. So, I mean, to me, it's a no-brainer. If you can start that mediation process and go through that mediation process, it is so much more advantageous.
Well, and I think even when you're looking at the document collection, like you talked about, or the process, you know, part of it you can kind of liken to the telephone game. And so if you don't have the financial person in the room or as part of the discussions, then what happens is we're communicating to the client and then the client communicates to the attorney and then we communicate to the attorney and then the attorney communicates to the client. And each time, because we're talking about such complex matters, even if we're presenting, you know, we present a lot of it online to everybody involved. it is so difficult to understand that sometimes they have additional questions or additional issues or need some sort of clarification. So in mediation, you might have, if I'm just the one financial neutral or financial mediator in that capacity, I can just give the information. Oh, well, there's this case in Missouri and we can't get around it, and that says that you have to value certain things a certain way, right? Like that's easier to hear if you're both together, as opposed to if I tell you, you're gonna be like, well, let's get around that case, and I would say we're really supposed to be there for the court. We're supposed to be there for the sanctity of the family unit and saying, here's the reality. What do you guys choose to do within this reality? This makes sense. This is reasonable. This is reasonable. This is reasonable. And I think that that's a lot different than when you're litigating, because you're going to be fighting somebody or the other expert.
And New York State is known to be a litigious environment. So, yeah, there's lots to be said for that. I joke, one of my favorite jokes is, you call a litigator and they're like, okay, what do you got for me? And then you call a mediator and I get right into it. Like, okay, we got this, we got that. And the mediator will be like, wait a minute, you didn't tell me about your weekend. So, it just, night and day. And there are so many mediators that I know that will not litigate divorce matters because it's so contentious. Some food for thought.
Well, it's interesting because I think that a lot of mediators are lawyers or former judges. Yep. And, not a lot of financial people. A lot of financial people are kind of the side players that come in and give some information. But, it's difficult for an expert to be involved in litigation, but still try to mediate it, or try to settle it in some capacity. But that's typically what experts have been doing over the course of time, going in, trying to make things a little bit more understandable from financials. And then, hey, can you guys settle this? In litigation, you might have attorneys and clients that don't care and just want to continue to push forward and fight because they think they have a position that is legally better than your position. And so that's a different way of going about an issue in a family matter. That's a business. Like we see that in business litigation. You want to fight another corporation, companies fight companies, but this is a family. And I think that one of the things that's a little bit different in litigation and mediation is the communication. And the communication plays very much into it when you're dealing with families and parties that may not trust each other, right? So talk a little bit about maybe the differences in how we discuss matters in a litigation sense or mediation, and how we communicate even the financial picture.
I mean, I keep going back to the same thing. It's so much easier. It is so easy to facilitate conversations in mediation, because a lot of times, especially when it starts to get somewhat contentious, I always try to bring the couple back to, we all have a common goal. We have the common goal of trying to get through this and settle this in the easiest and way we possibly can, so that, for the rest of your lives, the two of you can communicate, especially if there are children involved, and communicate positively. Whereas in litigation, I don't know what it is, but there's always one party that is so much more bitter than the other party. And there'll be so many times that either the attorney's fostering it or the attorney cannot seem to get through to the client to calm them down. So, and to me, in that scenario, you should have a divorce coach, you should have a therapist, you need all of that And in mediation, if you've got a good mediator on board, and if I'm doing my job and explaining what's in front of you, there shouldn't be any animosity. I mean, there just shouldn't. And the big black hole that is divorce goes away because you're understanding. And I always notice there's always one person that was not the financially astute spouse, and it takes time to explain it to that person. And in mediation, time is allowed to do just that. Whereas in litigation, I mean, that person's self-esteem is horrific, because they think they should have known, and they're behind the 8 ball, and they're going to lose everything, and on and on and on. So does that make sense?
Yeah, and I think, like, from a communication standpoint, when we're involved as financial experts, I'm not going to communicate with the other side. I'm going to work for, my attorney, my client, and be facilitating and communicating to them. The only time the other side's going to get to communicate with me is in a deposition, which is still formal and recorded, and or trial, or if they, a lot of states are mandating mediation. And so, especially if you have children, or you might have to go to mediation for 2 or 4 hours before you get to see the judge in some of those states. So you might have some of that come in. But in mediation, I think, especially if you're working with a financial neutral or a joint expert, right, you can actually ask those questions. In litigation, both sides are holding on to their daggers, right? And they're like, I'm going to pull these out when it's the right time. And those are the positions that they take, right? Usually legal positions or financial positions. But in mediation, that's not the same way. We're going to communicate and say, okay, well, here's what I think. And you're putting everything on the table and saying, and then allowing everybody to say, well, that's actually a really big deal. Well, that's not a big deal. And I think what happens in litigation is everybody holds on to the end, like when you get to deposition or when you get to trial, to like say, look, I got you. And then it's like, oh, that wasn't a good getcha. Like, you saved that, but it wasn't a good one. And, it was actually like a butter knife, not a dagger. So I think in mediation, you have that capability to say, hey, expert, can you tell me if these are big deals are in the state? Or so that would be another, I think, area from a communication standpoint that's a little bit different.
Right. And I don't think in mediation, no one is fostering, looking for those daggers and
Right.
pointing the gun, which is wonderful because, again, I've worked with couples that were married 30, 40, 50 years, and they have grandchildren together, and in litigation, it's a one-upmanship. And there's nothing wrong with getting divorced. There's nothing wrong with doing I've seen contested divorces successfully mediated with the two attorneys, and it never went to court.
I mean, we're even seeing, from a communication standpoint, I think that's going to be your red flags for, like, if you have significant communication issues with your spouse, if you're not communicating about the finances, if you're in the dark about the finances, if you think the person is not trustworthy and is lying, all of those things are going to be triggers of, like, mediation may or may not be the best route for you. But we've seen that even if you think your spouse is lying, even if you think that they have manipulated money in the business or in your own personal matters, if you both come to the table and say, hey, I don't trust you, and the other person says, I probably did some things that you shouldn't trust, but I didn't move the money, I didn't change the money, there's ways to have somebody come in and look at it from a financial aspect and have it be a very tight or narrow look. And then they come back in and they say, guess what? You are both right, but it wasn't that much, right? It will appease people from an emotional standpoint and the financial, but that communication has to be there to engage that level of, agreement. Like, again, if you didn't do anything with the money, having somebody come and take a look and clear your name for a small amount or for a contained amount. Have you seen ways like that we can kind of assist in the process?
Yeah, it's funny that you say that, because especially with valuations, based upon the level of trust and where the couple is with that level of trust, we can tailor the process to what they would find acceptable. And so, and I think maybe we want to save it for our business valuation episode, Melissa. So that we could really get into the nuts and bolts. There's too much to talk about. But yes, I mean, that's the wonderful thing about mediation, is that you can tailor it to what the couple's needs are. And you can go with the pace that the couple wants to go to.
Here's the thing is, like, for the most part, when people fight in court, litigation, or in any context, it is typically about the money or kids, right? So let's assume that it's about the money. The only people that have that knowledge is the valuators or the business experts or the CPAs and things like that, right? CDFAs, whatever, that come into it. But there's also the legal issues. And so sometimes the attorney is governing the whole legal strategy and legal issues and ignoring some of the financial pieces. Whereas in mediation, you might be able to more freely speak your issues, right? Instead of going through the attorneys and trying to communicate via the telephone game. And you're also at the behest of the legal strategy. You could be like, oh, I just want to be done with this and I want to give this to my spouse. And the attorneys are going to be like, absolutely, categorically, no, you can't do that.
Yeah. In the litigation setting, to me, the attorney's the quarterback. And I'm just one of the players, and I'm waiting to see what the play is.
Yeah.
So, yeah.
I will say I typically tell them that I'm the financial quarterback and they can keep the legal quarterback, but like we're gonna have two. So, but that gets us to a little. I know, but that's what it is. Because and I think that for our other listeners, I mean, that is an important distinguishing factor. Is that this may be a legal situation that you are in to get unbound by this marriage because it was a legal contract to come together. But nobody told you when you got married how you were going to financially unwind this. And then they didn't tell you, it kind of depends on where you get divorced in the country. Like it's going to be state specific. If you get divorced in New York, different rules than Missouri. So the financial piece has to have a quarterback because the lawyer doesn't know enough. I've done the most sophisticated cases with the most sophisticated attorneys. There's still a disconnect in understanding fully how all of these pieces are kind of melded together, right?
Yeah, agreed. And I've actually worked with people to get their financial information together before they hired their attorneys successfully. And it saved them so much time and money, and they got such a better understanding of their financial position in such a shorter period of time. So,
and I completely think that those are our capabilities, and if anything, and we we learned it more in the collaborative law space, that realistically a couple, if you have already agreed with your spouse that we want to get divorced, we have some complexity, and that could just mean that like we have some issues that we don't know how to, like I had an inheritance, what do we do with it, right? Or I have this deferred compensation, how do we deal with it? If you and your spouse can agree that we at least want to talk to the same people, hiring a financial person first is the time that it normally takes. We use that time in litigation and we need that time to do it. But if you're prepping for going through a mediation, I think you can get all of these pieces. Like you can go to the valuator and get a summary of the valuation. You can go to the pension valuator and get a summary of the pension. You can go over here and get all of these pieces, and then you go to mediation. And part of it is because some of those pieces you might want privacy and confidentiality around, because not everybody has the cleanest history, right? But talk to us a little bit about how that is different than in litigation, in open court, in, like, do we really have privacy or confidentiality in either situation?
Well, I mean, when you're in mediation, right? It's the couple, the mediator, and the financial neutral, or again, the financial neutral could be the mediator. When you're going through litigation, it's the attorney, it's the paralegal, it's the receptionist when you're calling in, it's the judge, it's the law clerk, it's the other side. It's, oh my God, it's you have no privacy, you have no confidentiality. Everybody knows what's going on with your matter. I mean, I've seen judges roll their eyes when they saw certain people coming into their courtroom. No exaggeration, rolling their eyes now. And this is a judge. So I think, just to, and look, I do more litigation than I do mediation at this point. I just think that there's so much more dignity with mediation than there is, litigation, but you've got to have the right temperament and you have to want to do it. So, there are certain personalities that it doesn't align with. So,
well, and I think that privacy and confidentiality are usually big issues for people. And in the legal environment, your information could even be accessible by all other attorneys, unless you create a case that's confidential or protected. And there are measures that you have to go through in the court system to protect that case and have it be private, even in that capacity. But I also think that there's some, like we see a lot of businesses that are probably improperly filing tax returns, or doing various like discretionary expenses through the business. So in some capacity, you also want some privacy on how you have financially conducted yourself, and that is more capable in a mediation than, I mean, I've had crazy cases where they don't want to disclose that, the hunting trip was actually a trip with all the girlfriends and all the partners, and it was expensed, to the tune of $50,000 on the income statement. Like those types of things, you may not want the judge to know because the judge works for the government and the IRS is the government.
Yeah, well, I've had a judge say, like, even before I opened my mouth, you all need to fix this. You all need to settle this before Rosalia opens her mouth, because they have a duty to report it to the IRS. And I don't know if a lot of people realize that. So
I don't think people realize it. And for a long time, I've been doing this for 20 years, and they've always talked about it in the trainings, like, be prepared. This could happen. It did happen to me in a case, and it was shut down very quickly. So, and basically the judge said the same thing. Like, I don't want to hear anymore about this testimony. But another area that I think that people don't understand is that you and I do a lot of litigation as experts, right? And there's a very big difference. We talked about this briefly before we came on, is that what the most experience that I have gotten in negotiation and mediation has been based in cases that were in litigation. And so it's really, we have to operate in that space and try to get people to settle based on negotiation techniques and tactics. But in mediation, it's also different, right? Do you want to talk a little bit about, the ways that people negotiate in litigation as opposed to, or even do offers of settlement or any of that? Do you want to talk a little bit about that?
Oh my goodness. So in litigation, so one side's attorney will send in a proposal, right? And so the other side is like, what is this? This is garbage, not accepted. No, 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 no. And then the other side is like, why don't you accept it? Okay, here's a better offer. You didn't respond to the first offer. What's wrong with the third offer? Well, you didn't give me this and you didn't give me this and blah, 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 blah. And I remember being involved in one negotiation and the attorney's like, Rosalia, you've got to get this woman to settle. I don't know why she's not, this is a very generous offer. And I said to her, how many pairs of Christian Louboutins do you have in your closet? And how many more are you going to buy? You're in your late 50s. Do you really need them? And she started laughing. And lo and behold, we were able to reduce some allowances and expenses, and it settled. But the back and forth can take months upon months. In mediation, everybody's at the table. Everyone is at the table. If there is something that someone doesn't agree with, it's there and it's right there and then it gets addressed. Obviously people need to think and they can walk away and come back for another session. But it's just so much more amicable. It really is. But yeah, it gets messy. It can get messy in litigation. And then you can have the experts trying to negotiate, business valuations. And, there's a problem when two valuations are so far apart that there's just no negotiating it, because generally that means that one side just doesn't understand. I don't know if you've seen that at all, but I see that. So,
well, it happens. I would say I think it's an issue with, our profession and other types of things too, is that we're still not able to check that bias sometimes in the court, so you're looking at a position that's higher or lower. Whereas I think in negotiation, especially in mediation, one of the things that we try to show people is like, here's the range of value. Like, it isn't going to be between 1 million and 50 million. It's going to be between 14.5 and 15.5 or 17. It's going to be a tight range that addresses some of the issues in the subjectivity of things. But the negotiation process in litigation, you're paying all of this money and getting all the way prepped in order to then start negotiating way down the pipeline. As opposed to in mediation, sometimes you can let's start with the finances. And I always try to encourage people to be honest. Like, if you don't want the house, don't try to hold on to the house because I'm only going to trade you the house for something else. Like, don't do these used car salesmen kind of, we always pick on used car salesmen, but don't use these old tactics of like coercive control, or I'm going to hold this back to trade it with you in the future. Like, all of those become transparent and superfluous if you're saying, listen, this is how I could be whole at the end of it. I need to have that. I need to have a comfortable place to live, some money going forward until I can find a job or get, things like that. If people started to communicate at that level, then you can say, oh, I understand. It's going to be hard for us, but let's do that. As opposed in litigation, it's going to be like, well, good luck. Hope the judge gives it to you.
Or you're never going to get that. Going to trial is a crapshoot, but I guarantee you're never going to get that.
Mm-hmm. Or the judge is going to sell it. There's some jurisdictions that a judge can actually force a sale of something, a business, a house, but there's a lot of jurisdictions where the judge cannot. And you have to understand, again, we're jumping through legal hurdles on financial issues. So it's really starting to just identify, is this a legal issue or a financial issue? And if it's a financial issue, has anybody given you the rubber stamp that it's okay? Because you can hire a consultant, you can hire an expert, you can hire somebody to just review it. Like, I would say a lot of our work right now is somebody saying, I've worked with somebody for years, like I hate to say that, but for a long time in their divorce, and they still don't have what they need financially to get separated. So that's some of the area. Or I've had a situation where both people have inheritances, right? Or both people have separate assets. How do you look at those things? So, well, tell us a little bit more. I think we kind of skip about the person until the end. And so we've talked kind of in general about a lot of different topics and ways that litigation is different than litigation and mediation are different. And we're going to talk more about some of these things in future podcasts. But tell us a little bit more about Rosalia and what you do and how you got involved with this, because I think that'll give them some idea of bandwidth for this conversation. And going forward, people can have questions about the differences, and we can discuss them on future podcasts. But let's talk about your background and some of the things that you deal with in New York that I think are also unique as well.
Excuse me. So let's see. I came out of Deloitte & Touche, and it was actually Touche when I came out of auditing, if you will. So that kind of dates me. And I got
before you keep on going, it's funny. One of my former bosses was like the first woman partner at Touche and Ross. Maybe was that the old
Ross? Yeah, there were no partners there. There was this invisible senior manager, female, that no one ever saw. And I was in the Manhattan office. No one ever saw this woman. Never. I never saw her, and I looked for her. Trust me. But so I had come out of Touche Ross and got married, had the kids, took some time off, and then was faced with my own divorce. And interestingly enough, the attorney wanted to hire a financial person to work on my matter. That financial person ended up hiring me. She was like, why don't you work on your own divorce? I'll show you what to do. And I started working for this boutique firm, and it was great. I love what I do. It's probably the fact that I've gone through the process really helps me to understand the emotional component of it, as well as the financial component of it. And I would say probably 70 to 80% of my practice is divorce related, anything and everything divorce related. So, as I said, I think during, the presentation here, New York can be a very litigious environment, very litigious. I know that, this was one statistic, and I think it still holds true, that upper middle class in Manhattan, the average divorce could cost $1 million between the experts and the attorneys, which, and I can see why. I can certainly see why. So yeah, so it's I enjoy.
Well,
Go ahead.
I think some of the interesting pieces, and I don't see a tremendous amount of experts in the country that kind of focus on business valuation, divorce, having other financial, like a CPA or, a financial advisor, things like that, having other financial knowledge. And then you have to layer in that it's state specific. So you have to understand like what's happening in your state.
Right.
That is also important, right? Do you find that you operate mostly out of a few handful of states, or how do you operate?
Yeah, I mean, I've successfully, kind of been in the tri-state area, and it's worked. There's, look, the nature of our business is to figure out what's going on elsewhere. And that's, a lot of times there's an attorney or a mediator that can explain it to us if we don't know. But we're always learning. But I don't know. I think one of the biggest things is that I've also got the financial forensics background, and I think that lends itself hand in hand with the business valuation. So you can see everything, and you can see how all of the various parts, especially in a complex matter, interact with each other, right? Because I'm sure you see it all the time as well, Melissa.
Yeah. Well, and I think that, going forward, it's hard to take this topic in one podcast. And we knew that going into it, that it was going to be a lot. So we've kind of, given people some idea of who we are, some idea of some of the topics that we can talk about. And I think that going forward, it will be, if people have additional questions, because the reality is a lot of mediators have some of these questions too, because mediators don't always operate in litigation. And litigation is kind of big, bad, and scary for the most part for people until it's not, right? Until you get enough experience to understand what you're doing.
And I think it's really important for the mediators to understand what's currently going on in the legal system, especially when you're trying to mediate a matter, because that makes all the difference in the world. I think not having that knowledge or that information can really set the couple back. Because you don't know what's going to happen. You don't know, they say that trial is a crapshoot. But I think that the mediator also needs to be knowledgeable in terms of what you think you can get, versus what's just not going to happen. Because as you know, a lot of times people can be extremely unreasonable, and they need to be brought back down to earth, if you will.
Yeah, no, I completely agree. I think that we'll touch on a lot more of the topics in the valuation podcast, because, the valuation piece is a difficult piece of you can't just be a CPA or a financial planner or a CDFA or any of them and handle it when there's a business involved. So that's really the complexity that happens when we get involved. It's not just a house and a car, it's some other things. But if people have questions, they can reach out to you. You've provided your phone number, your email. I would assume that you take consultations and talk to people, especially. And, if you're in the middle of a divorce right now and something just doesn't feel right, I think that's the time to reach out to somebody like us and just say, can I just have a consultation? Can I have your 30 minutes free and just say, is this crazy? Because if it is, it might be worth, like, typically when we're involved, it's worth it to you because it's a big deal, right? And we can tell usually if it's a big deal or a little deal, right?
Yeah, and I think I shared some stories, some more stories about people that just, it was their gut that was telling them something. It was their intuition, and they were so right, so right. So yeah, don't be afraid to call. Please, more than happy to field calls at any point during your process. So
And if you have the instinct and you have not seen documents, so if you have an instinct that something's not right and nobody has given you actual pieces of paper that are not handwritten, that have actual information from financial institutions, I would say pause everything and get a second opinion, because you need to. Mediation is notorious for people just saying, oh, this is just worth this, and they just go forward with it. So keep that in mind.
Or you don't need to look at that. It's okay. You can
Don't
both
worry.
agree.
We'll
It's
give it to you later.
Yeah.
I'll follow up with that. That's the typical, like, I'll follow up with that on a subsequent email. No, you're not. You're not going to. So, but we appreciate it, Rosalia. You're going to be a sort of a regular guest on the podcast. So we're going to continue to talk about these things. Hopefully we'll have people suggesting some additional, but I think we'll go into detail about some of these topics in future episodes. So we appreciate you and we look forward to seeing you again.
Oh, thank you so much, Melissa, for having me. And I look forward to it as well.
Awesome.